impatient and seeks short-term gains. Exactly because finance is efficient in responding to changing profit opportunities, it can become harmful for the rest of the economy. Coming more specifically to the world of banking work, I must preface my remarks with the fact that the third alteration to the 1999 Constitution, in coming with a new labor jurisprudence, to use the words of His Lordship Sirajo, is a game changer. His Lordship would go further to elaborately state, and I quote, "The court takes judicial notice of countless labor-related animosities which may hamper industrial relations if left to fester, hence the enactment. The contemplation of the drafters appears more in their preference for the lower court, the National Industrial Court, to take a proactive stance in ensuring that the nation will not be left out in the reckoning of the Committee of Nations in the area of robustly flourishing labor practices and industrial relations. The court hereby reiterates that the clarion call is to the stakeholders in labor and industrial relations to strive in order to conform with the international best practices as obtainable in the field," unquote. These words, though general to the world of work, applies with stronger force to the world of banking work. Hence, His Lordship Oguwumiju JSC would in a recent decision of the Supreme Court, Skybank PLC versus Adegum, concur in the following words, and I quote, "The new jurisprudence in labor relations cannot be ignored as the law is not static. The circumstances of each case and the motive of the employer is now a considerable factor in cases of wrongful dismissal. The new labor jurisprudence with the third alteration to the 1999 Constitution and provisions of the law in that regard, particularly Section 7(6) of the National Industrial Court Act, mandates that every court in the land shall have recourse to good or international best practices in labor or industrial relations. There is no doubt that the policy of the legislature to introduce new labor relation principles and international best practices into the adjudication of law in employment and labor relations is yet a fluid policy, merely pointing the judex to the new road to follow. There must not be confusion," unquote. Last year, the same Justice of the Supreme Court, in a matter the cause of action of which arose in 1995, long before the third alteration came, and dealing with the issue of restructuring exercise, in a concurring judgment, was quite specific in saying that it is therefore in the best interest of employers to follow the letters of the law and international best practices where applicable in the disengagement of their employees based on redundancy. For us then at the National Industrial Court, we have long recognized that the banking sector is a sensitive sector, and so extreme care must be taken as to how its employees are treated. Accordingly, the termination of the employment of a bank employee with immediate effect suggests some wrongdoing, which the bank must justify. If the termination is to be upheld, if unjustified, the termination would attract more than the common law measure of damages, i.e., payment in lieu of notice. This viewpoint now has the support, at least, of the concurring judgment of His Lordship Oguwumiju JSC in Skybank PLC versus Mr. Adedokun Olusegun Adegun. Actually, the decision was given in February of this year. Additionally, over time, we have been able to strike down a number of banking practices given our jurisdiction and power over the application of ratified international labor standards, and unfair labor practices. I'll give a few examples. 1. Given that an employee has the unfettered right to resign, relying on Section 34(1)(c) of the 1999 Constitution, Section 73(1) of the Labor Act, and the ILO Convention concerning forced or compulsory labor, Convention 29, which Nigeria ratified on 17 October 1960, we have ruled against what we call the Unity Bank Clause. The name is actually named after a case brought against Unity Bank, which found in that clause found in some employers' conditions of service simply states that you cannot resign if you are being investigated for a wrongdoing. So the Unity Bank Clause is a clause in the conditions of service where the employer reserves the right to reject the resignation of an employee simply because the employee in question is being investigated for an infraction. In any event, the rule that there is an absolute unfettered right to resign finds support even in Section 306, 1 and 2 of the 1999 Constitution in terms of constitutional office holders. What we have done is to strike down such a clause as being an aspect of compulsory labor. In other words, once an employee says, I want to go, you need to release him. Otherwise, anything he does after that is compulsory labor. 2, we also struck down a practice of an employer opening a virtual salary account for a claimant and 17 other employees. We held that this virtual salary account should never be accepted in our employment and labor relations, as it is demeaning to the dignity of the worker or employee, and so offends Section 34 of the 1999 Constitution. With the virtual salary account, what happened really was that an account was opened in the name of the employer, but for the benefit of a number of employees who were simply giving cards to access the account. If you read the labor laws, employees are entitled to choose which bank they want their salaries to be paid into. 3, we not only assume jurisdiction over staff loans when banks give their own staff loans. One such is reflected in the conditions of service. We frown on employers recalling staff loans at commercial interest rates where the termination of services of an employee is for no fault of his. We've seen situations where a bank would give a loan to a staff, repayment period is over a period of 15 years, 2 years into it, for no fault, at least disclose, we see a letter simply being written, your services are no longer needed. And because the employer has terminated the employee, he recalls the loan at now commercial interest rate and says, we are using your benefits to pay for the loan and hope that you will find a way, if it does not pay all, to fit in the balance. We've struck down on such practices as being unfair labor practices. 4, we have also struck down as unfair labor practice a bank dictating to an employee where to invest his or her computed gratuity benefit. 5, further struck down as unfair labor practice is a bank unlawfully placing a lien on an employee's account or freezing the employee's account's domicile with it. Lastly, we have also held it to be unlawful the refusal by a bank to issue work reference in favor of the claimant. And when it chose to react, it stated categorically that it is not giving the work reference because the claimant is indebted to it. A reason that was false and misleading. So, while the categories of unfair labor practices are not closed, these have been given as illustrations of practices in especially the world of banking work have met the disapproval of the NICN. The disapproval is a product of the new labor jurisprudence that is with us now, which it is in the interest of the banks to learn and imbibe. And as the courts have enjoined employers generally, it is in the interest of banks to conform with international best practices